Assalamualaikum warahmatullahi wabarakatuh to Dr. Karia. So today our group will be presenting on question number 3. So first, I will introduce myself and introducing my members as well. My name is Nabila binti Muhammad Karibi, and my two other group mates will be Nur Shasha binti Shawal Zaman as well as Nur Shakia binti Muhammad Jafar. So our scenario is basically about 3 members of parliament, which is we call as MPs, involved in this scenario, which are Tan Sri Baru. He is a Minister of Legal Affairs, Datuk Sri Buru, an opposition MP, as well as Datuk Babu, an independent MP. So Tan Sri Baru's situation is that he criticized his party president, who is also the Prime Minister, for not tackling corruption. As a result, he was stripped of party membership as well as removed from the cabinet as ministers, and claims the process was unfair and arbitrary because he wasn't given a chance to defend himself and he was exercising freedom of speech. And for Dato Sri Buru's situation is that he was expelled from his opposition party and he then formed a new political party and become its president. And the speaker declaration and reaction was that Speaker of Dewan Rakyat declares that Tan Sri Baru and Datuk Seri Buru's seats are now vacant, and the reason is because they were elected under one party but changed parties afterwards. And both MPs object and argue their political rights were violated, and claiming they should be allowed to join or form a new parties. Next issue is on Datuk Babu, which Datuk Babu is an independent MP. He pledged support to the Prime Minister but didn't officially join a party. And Tan Sri Baru and Datuk Sri Buru demand his seat be declared vacant too. But the Speaker refused, saying pledging support is not the same as changing parties. So the legal action taken by Tan Sri Baru and Datuk Sri Buru to the Speaker, and they want the court to compel the Speaker to also declare Datuk Babu's seat vacant. So there are many issues extracted based on the scenario just now, which we extracted as whether Tan Sri Baru's dismissal from the cabinet was lawful considering he was not given a fair trial or hearing before being removed. The second one is that whether Tan Sri Baru's removal from the cabinet and expulsion from the party violated his right to freedom of speech under Article 10 Clause 1A of the Federal Constitution, whether the Speaker declaration that Tan Sri Baru has vacated his parliamentary seat violates Article 10(1)(c) of the Federal Constitution. The fourth one will be whether Datuk Sri Buru rights to freedom of association under Article 10(1)(c) is violated by being penalised for forming or joining a political parties, and whether Datuk Babu's action of pledging support to the Prime Minister is consistent with his constitutional right to freedom of association under Article 10, and last but not least, whether the Speaker refusal to declare Datuk Babu's seat vacant while declaring the seat of Tan Sri Baru and Datuk Sri Buru vacant violates Article 8, Clause 1 on equality before the law. So this issue, we make it into parts whereby there's issue for Tan Sri Baru's, and then Datuk Sri Buru, and last but not least will be Datuk Babu.
Moving on to the first character for the scenario, which is Tan Sri Baru. So we have 3 issues that we extract from here. So the first one is whether Tan Sri Baru's dismissal from the cabinet was lawful, considering he was not given a fair trial or hearing before being removed. And for the second issue is that whether the Speaker's declaration that Tan Sri Baru has vacated his parliamentary seats violates Article 10, Clause 1, Paragraph C of the Federal Constitution. And for the last issue that we extracted is whether Tan Sri Baru's removal from the cabinet and expulsion from the party violated his right to freedom of speech and expression under Article 10, Clause 1, Paragraph E of the Federal Constitution. So the first issue is whether Tan Sri Baru's dismissal from the cabinet was lawful, considering he was not given a fair trial or hearing before being removed. So as for this issue, in appointing a cabinet, the Yang Pertuan Agong shall first appoint a minister and subsequently appoint the other ministers with the advice of Prime Minister from among the members of either House of the Parliament as laid down under Article 43, Clause 2 of the Federal Constitution. Okay, moreover, according to Article 43, Clause 5 of the Federal Constitution, ministers, apart from the Prime Minister, hold office at the pleasure of the YPA, subject to the advice of Prime Minister. So this means that the Prime Minister has the authority to revoke a minister's appointment after being consulted with the YPA. Moving on, if a dismissal of a minister is not aligned with the right procedure as mentioned above, so this is when the right of a particular minister under Article 5, Clause 1 of the Federal Constitution must be further discussed. So in the provision, it is provided that no person shall be deprived of his life or personal liberty save in accordance with the law. So focusing on the phrase of word liberty, it relates with the right of a fair trial, which also highlights the principle of natural justice. So referring to the term of fair trial, it holds the concept of deciding on a certain matter where both of the disputed parties must be heard, must be given a chance to explain themselves. Okay, so which is linked to the famous legal maxim, which is the audi alteram partem. To apply, so in this case, Tan Sri Baru was a cabinet member, which is a political appointment, a minister that being appointed by the YPA with advice from Prime Minister as mentioned in Article 43, Clause 2. So his role was held at the pleasure of YPA. So under Article 43, Clause 5, it is within the constitutional discretion of the Prime Minister to advise Yang Pertuan Agong to revoke his appointment. So as can be seen in the scenario, Tan Sri Baru has been removed from the cabinet and no longer holds the position of minister as announced by the Prime Minister. So here, it is apparent that the announcement was made independently by the Prime Minister and not being consulted with the YPA. So here, not only that, as mentioned in Article 43, Clause 5, the appointment of any minister shall be revoked by YPA. So which shows that only YPA has the discretion to remove or to announce the removal of a minister. Okay, thus the removal of Tan Sri Baru's position was made solely by the Prime Minister, which is unfair because it is not being made in accordance with the article. Okay, so This will cause a raise of issue of right to be heard on the part of Tan Sri Baru, as his dismissal was not in accordance with the right procedure. So looking at the scenario, his removal also was announced in a special party involving members of the party itself, indicating the party was informal and deviated from a true process of for a removal of a minister. Hence, Tan Sri Baru has the right to defend himself from the unfair treatment, as he was supposed to be given a right to be heard and to be informed of the basis of his removal, as highlighted in Article 5, Clause 1 of the Federal Constitution. So, to conclude, Tan Sri Baru's dismissal from the cabinet was unlawful under Article 43, Clause 5 of the Federal Constitution, as it was made unfairly, and he had no right to be heard and informed of the removal's basis following the principle of natural justice. Moving on to the second issue, which is whether the Speaker's declaration that Tan Sri Baru has vacated his parliamentary seat violates Article 10, Clause 1, Paragraph C of the Federal Constitution. So, under Article 10, Clause 1, Paragraph C of the Federal Constitution, it is provided that all citizens have the right to form associations. Okay, freedom of association is a right that is enjoyed by most of the people. These rights ensure that every individual is free to organize and to form and particularly to participate in groups, either formally or informally. Moreover, freedom of association is a fundamental human right that is crucial to the functioning of a democracy and an essential condition for the exercise of other human rights as well. Okay, so association plays an important role in achieving goals that are in the public interest and are essential actors in supporting the protection of human rights. And not only that, the right to freedom of association covers organized and professional organizations such as political parties, trade unions, public associations, and many more. Referring to the case of Nordin bin Tali and another, and Dewan Undangan Negeri Kelantan and others, the High Court explains that the freedom of association has been described as a claim of the individual to be permitted to establish relations with other of his own choosing for the purpose of obtaining for the whole group, usually against outside individuals or groups, some special strength or advantage in the pursuit of a common end. So the freedom to form an association necessarily includes negative rights of not joining an association, in as much as the right to form an association necessarily implies the freedom of violation to form or not to form, to join or not to join an association. Hence, to compel a person by law to become a member of an association is clearly a violation of his fundamental right. On top of that, according to Article 49A, Clause 3, the Speaker shall declare a seat vacant whenever the Speaker receives a written notice from any member of the House of Representatives on the occurrence of a casual vacancy among the members of the House. So that's for the rules under this issue. And moving on to the application. So basically, in this case, to apply. In this case, Tan Sri Baru was expelled from his political party after expressing criticism of the party leadership, specifically the Prime Minister. Following this expulsion, the Speaker of Dewan Rakyat declared that Tan Sri Baru had vacated his seat under Article 49A, Clause 1, Paragraph A of the Federal Constitution, which provides that a member of Parliament who ceases to be a member of the political party under which he was elected shall lose his seat. So, however, Tan Sri Baru may argue that his right to freedom of association under Article 10, Clause 1, Paragraph C has been violated. So, this is because he was forced out of the party and as a result was compelled to leave Parliament. Even though he did not voluntarily leave the Parliament or did not voluntarily remove himself from Parliament. So his expulsion was also carried out without giving him an opportunity to be heard, which raises serious concerns about fairness and the respect for fundamental liberties, which I mentioned in the previous issue. So, according to the case of Nordin bin Sani, by applying that case, freedom of association includes both of the positive right to join and the negative right not to be forced into or out of an association. So, by expelling him without due process, then having the Speaker declare his seat vacant, Tan Sri Baru's right to remain in an association of his choice may have been unfairly taken away. So, moreover, Article 49A, Clause 3, requires the Speaker to act only after receiving a formal written notice from the political party. So, if this notice was issued without following proper internal party procedures or without allowing Tan Sri Baru to defend himself, then the Speaker's action may be constitutionally questionable as it relies on possibly invalid expulsion. Therefore, the Speaker's declaration was made without following Article 49A, Clause 3, as there was no written notice received from the party of Tan Sri Baru pertaining to his expulsion, and thus the underlying process that led to the expulsion could be challenged for violating Tan Sri Baru's right under Article 10, Clause 1, Paragraph C. So, to conclude, Tan Sri Baru's right to freedom of association was violated as he was forced out of the party and being restricted to join an association while being expelled unfairly. Moving on, for the last issue for my part is whether Tan Sri Baru's removal from the cabinet and expulsion from the party violated his right to freedom of speech and expression under Article 10, Clause 1, Paragraph A of the Federal Constitution. So, Article 10, Clause 1, Paragraph A guarantees every citizen the right to freedom of speech and expression. However, this right is not absolute. Okay, right to freedom of speech and expression holds interpretation where everyone can hold opinions without interference to seek, receive, and impart information as well as ideas through any media and regardless of frontiers, as the scope is much wider than the provision itself. Okay, not just that, the right to freedom of speech also does not confine to words and writing. However, it also covers symbolic speech. Okay, furthermore, under Article 10, Clause 2, Paragraph A, Parliament may impose reasonable restrictions on this right if it is necessary in the interest of security, public order, morality, and other constitutional recognized grounds. Meanwhile, for the matter of concerning public interest, can be referred to the case of Utusan Melayu Berhad and Datuk Sri Diraja Haji Adnan bin Haji Yaakob, where a public official has the right to freedom of expression on public affairs. Okay, to apply based on our scenario, Tan Sri Baru's remarks, which criticize the Prime Minister handling of corruption, clearly fall within the core of political expression protected by Article 10, Clause 1, Paragraph A, where it allows a citizen to look for information, to receive information, and to disseminate or distribute the information. So any platform, tools, or medium of communication can be used in order to exercise this right. So referring to the stated provision, every citizen has the right to freedom of speech and expression. Okay, so Tan Sri Baru's criticism was on a matter concerning the leadership of the president, as he has a responsibility to perform his duty accordingly and justly without any biased behavior among the members of the party. So the act of Tan Sri Baru condemning him for not being brief enough to combat corruption shows that Tan Sri Baru had the intention to break the cycle of corruption which had been practiced within the party for quite some time. Okay, so Tan Sri Baru's action does not in any way fall within or under the restriction of Article 10, Clause 2, Paragraph A, as a matter to give a huge negative impact towards the party if it does not put a stop. So, as can be seen in the case of Putusan Melayu, Berhad and Datuk Sri Diraja Haji Adnan bin Haji Yaakob, the Court of Appeal held that the freedom of expression includes the public's right to discuss their government and public officials conducting public affairs of the government without the fear of being called to account in the court for their expressions of opinion. So, this shows that Tan Sri Baru has a right under Article 10, Clause 1, Paragraph A of the Constitution to be exercised as a matter is concerning public affairs because, like, if you're not brief enough to combat, it somehow triggers your leadership as well as responsibility of a minister because, like, the corruption matter is not a small matter, it's a huge matter, and it also impacts the public because how you handle such a matter, it also reflects on how actually you lead your party as well as the people in society. So, hence, the removal of Tan Sri Baru from the cabinet and his expulsion from the party clearly violated his right to freedom of speech under Article 10, Clause 1, Paragraph A of the Federal Constitution, as he was only speaking out about an important issue, which is corruption in the party, as I mentioned just now, and it is on matter that affects the public as well. So, besides, his words did not go against any of the restrictions that have been laid down in Article 10, Clause 2, Paragraph A, like national security or public order. Therefore, Tan Sri Baru's right to freedom of speech and expression under Article 10, Clause 1, Paragraph A has been violated, as his right to speak freely is taken away by means of expelling him from the party and deprive his right to be heard.
So next, I'll be explaining or presenting Datuk Sri Buruk's issues. But before that, my name is Nabila binti Muhammad Karibi. And the issue on Datuk Sri Buruk is that whether we think it is most relevant is that whether Datuk Sri Buruk's rights to freedom of association under Article 10(1)(c) is violated by being penalised for forming or joining new political parties. Okay, so moving on to the rules, the legal rules and the framework. So first, we took Article 10(1)(c) of the Federal Constitution, which every citizen has the right to form associations, which this includes political parties as a fundamental part of democratic participation and freedom of political expression. And next is Article 10(2)(c) of the Federal Constitution as well. Parliament may impose restrictions on this right by law only if necessary or expedient. So, which in the interest of the security of the Federation, public order, or morality, which restriction must be reasonable, proportionate, and enacted by the Parliament and not imposed arbitrarily by any executive or administrative body. Okay, so moving on to the Societies Act 1966, I would like to show what a society means. Section 2 defines society to include political parties, and Section 7, Clause 1, basically the ROS, the Registrar of Societies, may approve registration of a new political party. And Section 7, Clause 2 and 7, Clause 3, the Registrar may also refuse registration if the society is used for unlawful purposes, is prejudicial to public order or security, or the society is declared unlawful by minister. So as long as the party is registered lawfully and not refused under any of this ground, its formation will be legitimate as well as protected. So moving on to the case law that we think it is relevant. So first is Dewan Undangan Negeri Kelantan and another against Nordin Saleh. So in this case, the court struck down a state law that made MPs lose their seats for changing parties. So it was held that the law violated Article 10 Clause 1(c) because it was enacted by the it was not enacted by the Parliament, and also it did not fall under the permissible grounds in Article 10 Clause 2(c) that I've just mentioned previously. So this principle of the case principle is that forming or joining another political party is protected under clause Article 10(1)(c) unless unless it was restricted by valid federal law. And the next case will be Sivarasa Rasya and Badan Peguam Malaysia. So the federal court introduced the doctrine of proportionality in reviewing laws restricting Article 10 rights. So any restriction must pursue a legitimate aim, be rationally connected to the aim, and also be proportionate in effect. So applied here, any law or action affecting Datuk Sri Buruk's right must pass these three-part test. And last but not least is the Malaysian Bar and Government of Malaysia. So this legal principle is that the disqualification from association, like sitting on the bar council, must be reasonable and not arbitrary. So if classification or restriction is not justifiable, then it will be violating the Article 10(1)(c). Okay, so moving on to the application, Datuk Seri Buruk's formation of a new political party following his expulsion from his original party is constitutionally protected under Article 10(1)(c) of the Federal Constitution, which guarantees right to form association, which include political parties, as I mentioned just now. So this action does not amount to voluntary defection, but rather a lawful response to his expulsion. And the Speaker's declaration that he ceases to be an MP as a result is unjustifiable restriction on his freedom of association. So for such restriction to be valid under Article 10 to C, it must be imposed by federal legislation, pursue a legitimate aim such as public order or morality, and be proportionate. So, however, no federal law authorized to like the automatic removal of an MP for forming a new party, and there is no evidence also that Datuk Seri Buruk's party was refused registration or declared unlawful under the Societies Act 1966. And the Speaker's action mirrors the unconstitutional penalty which is struck down in Nordin Hassali, where party switching was not grounds for removal absent a valid federal law. Moreover, the unequal treatment compared to Datuk Baba, who faced no consequences for pledging support to a different party, further underscores that the arbitrary and discriminatory nature of the Speaker's decision. And therefore, the restriction imposed on Datuk Seri Buruk is unconstitutional. In the case of Siva Rasia and Badan Peguam Malaysia, basically forming a party after expulsion does not endanger the public order, security, or morality. So even if the speaker claims that political stability as a justification, vacating his seat is a disproportionate reason or penalty. And last but not least, in the case of Malaysia government, being penalized for forming a new party after expulsion is an arbitrary classification, not based on misconduct or any constitutional breach. So, to conclude, Datuk Seri Buruk's removal from Parliament for forming a new political party is an unlawful infringement of his fundamental liberty or under Article 10(1)(c), as there is no valid restriction under Article 10(2)(c) or the Societies Act to justify such action of expulsion. And the Speaker's declaration lacks constitutional and legislative basis, contradicts established case law, and there is therefore it was unconstitutional. So now let's look at the issues concerning Datuk Baba. So there are two issues that we have extracted from this scenario. So the first one is whether Datuk Baba's action of pledging support to the Prime Minister is consistent with his right, with his constitutional right to freedom of association under Article 10. And for the second one is whether the Speaker's refusal to declare Datuk Baba's seat vacant or declaring the seat of Tan Sri Baru and Datuk Sri Buruk vacant violates Article 8 Clause 1 on equality before the law. So now let's look at the first issue first, which is whether Datuk Baba's action of pledging support to the Prime Minister is consistent with his constitutional right to freedom of association under Article 10. So basically, in order for us to answer this issue, we will have to refer to the Federal Constitution as usual now. So basically, Article 10, Clause 1, Paragraph C provides that all citizens with the right to form association. So in other words, this provision guarantees every citizen with right to associate. However, it is important for us to remember that this right is only given and confined to Malaysian citizens only. And then not only that, the right guaranteed under Article 10 can also be limited by the grounds provided under Article 10, Clause 2. So there are a lot of grounds, but among others, Article 10, Clause 2A provides that Parliament may by law impose restriction or of any impose restriction designed to protect the privileges of Parliament or of any legislative assembly or to provide against contempt of court, defamation, or incitement to any offence. So basically, Article 10, Clause 2A provides that the Parliament may make law to restrict or to limit the rights under Article 10, Clause 1C in order to protect the privileges of Parliament or of any legislative assembly or even to provide against contempt of court, defamation, or incitement to any offences. So basically, we can see in the case of Nordin Saleh and State Legislative Assembly, Kelantan. So basically, in this case, the plaintiffs contend that the new articles of the Kelantan State Constitution is inconsistent with the provisions of Article 10, Clause 1C of the Federal Constitution and is therefore void under Article 4, Clause 1 of the Federal Constitution. So basically, in this case, the court held that Article 10, Clause 2 of the Federal Constitution only authorizes Parliament and not State Legislative Assembly to make law to impose restriction on the fundamental right of a citizen to form association. So basically, Article 10, Clause 2 provide that um, there can be there can be law to restrict the rights given under Article 10, Clause 1C. However, the law can only be made by the Parliament, and in this case, it was made by the SLA. Therefore, court held that the restriction is void because only the Parliament have such right to make the restriction. So applying to our current scenario here, Datuk Baba has the right to form association as what has been provided under Article 10, Clause 1C of the Federal Constitution. However, as provided under Article 10, Clause 2, the right to associate may be limited by the law imposed by the Parliament to protect the privileges of the Parliament. So, for example, the Parliament may impose restriction on the members of Parliament from freely associating in order to protect the interests of the Parliament. So, referring back to the case of Nordin Sani and State Legislative Assembly Kelantan, here, the State Legislative Assembly impose restriction upon the right of members of the Assembly in which they are restricted from exercising their right to freedom of associations. However, even though this restriction can be said to protect the privileges of the Parliament, but in this case, the court held that the restriction is void as Article 10, Clause 2 of the Federal Constitution authorizes only Parliament and not the State Legislative Assembly to make law to impose restriction. So, distinguishing from this case with our current scenario, here Datuk Baba's action of pledging support to the Prime Minister is consistent with the right guarantee under Article 10, Clause 1C. However, Like I've mentioned before, his right may be restricted by Article 49A of the Federal Constitution that provides, subject to the provision of this article, a member of the House of Representatives shall cease to be a member of the House and his seat shall become vacant immediately on a date a casual vacancy is established by the Speaker under Clause 3 if A. Having been elected to the House of Representatives as a member of a political party, 1. He resigned as a member of the political party, or 2. He ceases to be a member of the political party, or B. Having been elected to the House of Representatives, otherwise than as a member of a political party, he joins a political party as a member. So basically, Article 49A of the Federal Constitution serves as a limitation to the freedom of association guaranteed under Article 10, Clause 1C, in which Article 49A imposes a restriction on a member of the House of Representatives where they cannot freely associate. So unlike in the case of Rodian Sali in State Legislative Assembly Kelantan, this restriction is a valid restriction as it is in line with Article 10, Clause 2, as this restriction was made by the Parliament and it was actually introduced to protect the privileges of the Parliament. So basically, Article 49A, Clause 1B provides that if an independent member of Parliament joins a political party as a member after being elected, his seat will become vacant immediately. So this is one of the limitation to freedom of associations. So to conclude, Datuk Baba's action of pledging support to the Prime Minister is consistent with his constitutional right to freedom of association under Article 10. But since he is the members of the Parliament, his right may be restricted under Article 49A, Clause 1D. So another issue is related to Datuk Baba is whether the Speaker's refusal to declare Datuk Baba's seat vacant while declaring the seat of Tan Sri Baru and Datuk Sri Buruk vacant violates Article 8 Clause 1 on equality before the law. So basically, the rule of law implies that every person is equally subject to the law. The social, political, or even economic status of an individual is by itself no answer to legal proceedings, civil or criminal, meaning that there shall be no discriminations. And every citizen is under the same responsibility for every act done without any legal justification. And Article 8 Clause 1 of the Federal Constitution provides that all persons are equal before the law and are entitled to the equal protections of the law. So what does it mean by equal before the law and equal protections of the law? So referring to the case of PP and Su Liang Yu, the court held that the idea of the expression of equal before the law and equal protection of the law is equal justice. This Article 8 Clause 1 is actually providing equal justice in both substantive and procedural. And in order for us to determine whether that particular law complies with Article 8 or not, the first questions that need to be asked is whether the law is discriminatory. If it is not, then it is a good law and is consistent with Article 8. However, if the answer is the law is discriminatory, then we will have to ask another question, which is whether or is the discrimination in the law allowed. So if the discrimination is allowed, then the law is good of the law is a good law and is consistent with Article 8, and if it is not, then the law is not a good law. So however, there are some exceptions to the general rule that all persons are equal before the law and are entitled to the equal protections of the law. So among the exceptions that exist are when there is an express exception made by the Federal Constitution, for example, as what has been provided in Article 8, Clause 5 of the Federal Constitution. And it can also happen in situation where there is an implied exception or in situation where equality does not promote justice. So in the case of PP and Kong Ten Ken, the court highlighted that the underlying principle of Article 8 is that a law must operate alike on all persons under like circumstances. However, it provides that a law is not required to operate on all persons in any circumstances, and the law is also not required to be general in character and universal in application. So basically, in this case, it's trying to highlight that the law need to operate alike on all persons under like circumstances, meaning that if the circumstances is similar, then the law shall operate similarly. But if the circumstances is different, so that it is not necessary for the law to operate alike. So all in all, it provides that Article 8 does not prohibit the legislature and executive bodies from distinguishing and classifying persons based on their action. So applying the rule in our scenario, Tan Sri Baru, Datuk Sri Buru, and Datuk Baba should have equality before the law as what has been provided under Article 8 Clause 1 of the Federal Constitution that states all persons are equal before the law and are entitled to the equal protections of the law. And according to the case of PP and Su Liang Yu, the idea of Article 8 Clause 1 is that actually a person should be given equal justice. However, equal justice doesn't mean that everyone should be treated in the same way in all situations or circumstances. It depends on the circumstances. Like in the case of PP and Kong Ten Ken, the court highlighted that it is true that the underlying principle of Article 8 is that a law must operate alike on all persons under like circumstances. This means that when the circumstances are the same, then the law must operate alike. So in this scenario, the law in question is Article 49A, where it is about situation that will render the seat of the members of parliament vacant. And in this scenario, the issues of equality before the law arises when the speaker refused to declare Datuk Baba's seat vacant while declaring the seat of Tan Sri Baru and Datuk Sri Buruk vacant. It is important to note that the law needs to be referred here is Article 49A. In this article, it provides that if an independent member of parliament joins a political party as a member after being elected, his seats will become vacant immediately. However, in this scenario, Datuk Baba only pledged his support to the current Prime Minister. He didn't actually formally join the party. Thus, it can be said that his seat is unaffected as he did not actually join another party. Moreover, in the case of PP and Kong Ten Ken, the court highlighted that the underlying principle of Article 8 is that a law must operate alike on all persons under like circumstances. In this scenario, it is not necessary for the speaker to declare Datuk Baba seat vacant just because the seats of Tan Sri Baru and Datuk Sri Buruk vacant, as the circumstances is not the same. The situation of Datuk Baba doesn't render his seat to be affected by his act of waging support. And therefore, to conclude, the speaker's refusal to declare Datuk Baba's seat vacant while declaring the seat of Tan Sri Baru and Datuk Sri Buruk vacant does not violate Article 8 Clause 1 on equality before the law. So I think that's all from our group. Thank you.